Welcome to the podcast summary of Article 14 of the Constitution of Singapore. Today's thread running through everything is pretty simple. Singapore's constitution does protect speech, assembly, and association, but it builds the limits right into the promise. Once you follow that idea through the courts, media law, public order rules, defamation, and even censorship, you get a system that treats liberty as real but carefully managed, and very often subordinate to stability, security, and Parliament's judgment. Article 14 is Singapore citizens' freedom of speech and expression, peaceful assembly without arms and association. That sounds familiar if you've read other constitutions, but the important twist is that these rights are not framed as open-ended liberties that the state has to justify limiting later. The qualifications are built into the constitutional text itself. And that phrase, without arms, is doing real work. There's no general constitutional right to bear arms in Singapore. And the Arms and Explosives Act puts possession, import, export, manufacture, and dealing under a licensing regime. A big case here is Chi Siak Chin, Ministry of Home Affairs in 2005. The High Court read the phrase necessary or expedient very broadly and said Parliament has an extremely wide discretionary power when it restricts these rights. So the court's job is not to ask, was this restriction proportionate, or even was it the least restrictive option? It mainly asks whether there's a sufficient connection, a nexus, between the law and a permitted ground like public order or security. That's a major difference from systems that use a stronger proportionality test. Singapore's courts have been quite explicit that Article 14 does not contain the word reasonable, and that absence matters. Article 14 has another layer that makes things even tighter. For some grounds, Parliament acts under the necessary or expedient formula, but for others, including contempt of court, defamation, incitement to an offense, parliamentary privilege, and certain labor or education laws, the text can be read as not even requiring that threshold showing. In practical terms, critics say that can leave Parliament with something close to near unfettered authority to define the boundaries of the right simply by legislating. And then there's Article 149, which is even stronger. Security laws aimed at organized violence, disaffection, racial hostility, unlawful constitutional change, or broader threats to security can stand, even if they conflict with liberties including Article 14. Public order in Singapore is interpreted pretty broadly. It's not just about stopping an immediate riot or a fight breaking out in the next 10 minutes. It includes public peace, safety, tranquility, and social stability, which helps explain restrictions on loud disturbances, where and when meetings happen, heckling, threatening language, and conduct likely to trigger breaches of the peace. The official case for this has also been economic, not only security-based. Wong Kan Seng argued in 1993 that order and stability are essential for growth because contracts and property rights need a stable legal environment. So there's a nation-building logic here. Civil and political liberty may be treated as something that has to coexist with, and sometimes yield to, development goals. At the same time, the tone hasn't been purely shut down and be quiet. Lee Hsien Loong has urged citizens not to be passive bystanders and to debate with reason, passion, and conviction. It's a model of managed participation rather than unrestricted dissent. Another crucial feature is that Article 14 belongs expressly to citizens. That was confirmed in cases including Review Publishing v. Lee Hsien Loong in 2009. A non-citizen newspaper company couldn't rely directly on the constitutional speech guarantee, even though what happened to its publication could obviously affect Singapore readers. That citizen-only structure means foreign publishers, companies, and other non-citizen actors don't automatically get constitutional shelter under Article 14. It also leaves an open and cautious area around whether citizens have a constitutional right to receive information, not just to speak. This citizen-based design shows up very clearly in media regulation. The Broadcasting Act and the Newspaper and Printing Presses Act allow extensive control of political media. Online providers discussing Singapore political or religious issues may need registration and licenses. And unlicensed broadcasting can bring fines up to $200,000 and even imprisonment. Foreign media can also be treated as stepping into Singapore's domestic politics. In 1987, the Asian Wall Street Journal was found to be engaging in domestic politics, and its circulation was capped at 400 copies. And the courts have interpreted domestic politics broadly, covering Singapore's political system, governing ideology, public institutions, and government policies. So that category has a lot of reach. If you're wondering whether political speech gets special breathing room, Singapore's defamation law gives a pretty clear answer. Not much. In Jeyaretnam v. Lee Kuan Yew, the Court of Appeal rejected the idea that politicians and public officials should face a looser standard, like the American New York Times v. Sullivan rule. The court said false and defamatory allegations don't become acceptable just because they target political figures or surface during an election campaign. Later, in Review Publishing, the court also refused to import the Reynolds responsible journalism defense. At most, careful journalism might help reduce damages, but it won't wipe out liability. On contempt of court, the courts have tried to draw a somewhat more tailored line. In Shadrach v. Attorney General, the Court of Appeal adopted a real risk test. The publication has to create more than a remote or fanciful risk of undermining confidence in the administration of justice. Fair criticism still matters, though the court said it should generally be argued with evidence and stated in a temperate way. That's a narrower approach than the older inherent tendency formula, but still much stricter than the U.S. free speech tradition. Association is also tightly regulated. Under the Societies Act, groups of 10 or more usually have to register, and registration can be refused on grounds like public peace, welfare, good order, national interest, or problematic foreign links. Political groups and organizations discussing civil rights, religion, ethnicity, the environment, or how Singapore is governed can fall within it. And if a group is unregistered, just managing it, joining it, or attending its meetings can itself be an offense. Moral regulation works in a similar managed way. The Films Act and the Undesirable Publications Act support censorship, classification, and bans on obscene or objectionable material, with standards treated as evolving over time. A memorable example is Zoolander, which had its certificate withdrawn because of its assassination plot involving Malaysia's prime minister. So even when the issue isn't classic obscenity, political sensitivity and regional relations can still matter. A lot of this framework comes from constitutional inheritance, not just current politics. Article 14 closely tracks Malaysia's Article 10 and has some resemblance to India's Article 19. But Singapore's courts lean heavily on the fact that Article 14 lacks an express reasonableness requirement. There's also a Westminster flavor here, with strong parliamentary supremacy and common law continuity. Courts have sometimes treated inherited common law rules, especially defamation, as part of the law that can restrict Article 14 rights. Critics say that flips the normal constitutional logic on its head, because instead of rights testing old legal restrictions, old restrictions can end up looking valid by default. So the big picture is that Singapore's constitutional liberties are genuine, but they're deliberately qualified, citizen-specific, and heavily shaped by public order, reputation, security, and legislative discretion. If you want one phrase to keep in mind, it's probably managed freedom. Not the punchiest slogan in the world, but it does explain a lot. This episode was generated by Podkey. Create your own at podkey.fm.